Under EFTA, which is the Electronic Funds Transfer Act, the bank, upon receipt of a dispute from a consumer, whether that dispute is submitted telephonically or through the mail, and that dispute relates to an unauthorized withdrawal from the account, the bank has to go through and investigate to determine, was this our customer who authorized a transaction or made the transaction occur, or was this transaction committed by a fraudster without our client's knowledge or consent? If the bank fails to do a reasonable investigation, that's when you, the consumer, can come along and sue your bank for that violation. If the fraud claim is wrongfully denied, what that means is that you've had an unauthorized transaction on your account, you've submitted a dispute that explained, the situation, and for whatever reason, your bank came along and said, well, actually, you did make that transaction. This is something that you're responsible for. At that point, the consumer can bring a claim under EFTA, the Electronic Funds Transfer Act, and hold their bank liable for not returning their funds and for wrongfully rejecting their claim. To file a complaint against your bank for an EFTA violation, what you need to do, and what I recommend doing, is reach out to a consumer protection law firm, whether it's loker.law or another one, because you're going to be going into federal court. The rules are very strict and they're very rigid. I wouldn't recommend doing it yourself. I would strongly recommend finding someone who has a focus on such claims. I'd recommend filing a lawsuit against your bank for EFTA violations if you see any type of fraudulent transaction on your account. Litigation against your bank is really the easiest and most effective way to get the bank to protect you from future fraud. The direct disputes, or worse, doing nothing, is going to allow the fraudster to continue to take your money, and sometimes with the information that they have about you, they can open more bank accounts or credit cards or take out loans in your name. So it's best to do something and to initiate litigation. The worst thing you can do is nothing and just let it go unaccounted for. EFTA violations run through the court system in typically 6 months, maybe 5 months. These cases go faster than what a lot of consumers believe. A lot of consumers reach out to loker.law and they think their case is going to take years. But fortunately, these claims get resolved quite quickly as compared to what people expect. A recent claim pursuant to the Electronic Funds Transfer Act came to us when, unfortunately, an elderly client was socially engineered. What that means is that the fraudster contacted our client pretending to be their bank and said, hey, did you just authorize this transaction? And of course, the client said, no, that wasn't me. Then the fraudster took our client through a series of questions, confirming name, date of birth, social, all of the information that the fraudster would then utilize to go steal the remainder of our client's funds. These funds were $80,000. This $80,000 represented every single penny that our client had spent decades earning. Unfortunately, she went from thinking she was going to retire to having no money in her pocket. And what we did from there is we were able to bring a successful EFTA claim against the bank on behalf of our client because the signs of fraud were so obvious. Anyone should have known, looking at the records, that this was not our client who withdrew quite suddenly all of the money that she spent her entire life earning. This EFTA claim resulted in her getting not only her money back, but over $1 million in her pocket. If your bank has denied your fraud claim, whether it's your own fraud claim or a parent's fraud claim or a grandparent's fraud claim, give loker.law a call right away, because what we can do is we can assist you with the dispute process, and if the bank still refuses to pay attention to you, we can bring a claim immediately on your behalf at no cost at any time.